Denise Howell here, and next up on This Week in Law, is ITV the next Napster or the next EchoStar? Will Suddenlink tick off subscribers with its 3 strikes policy? Will Google tick off trademark holders with its instant search? Eric Goldman, Evan Brown, and Matt Cooper consider this, plus the Snooki effect, next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 80, Never Not Awesome. This episode is brought to you by Squarespace.com, the fast and easy way to publish a high-quality website or blog. For a free trial and 10% off the lifetime of your new account, go to Squarespace.com and use TWiL, T-W-I-L, as your offer code. Hello and welcome to This Week in Law. I'm Denise Howell, and you're here with us for episode 80 of the show. We've got a great panel for you today. Joining us once again is Professor Eric Goldman from Santa Clara University's School of Law. Hi, Eric.
Hello, how are you?
Wonderful. Great to have you back on the show. Also joining us is Evan Brown from Hinshaw and Culbertson in Chicago and InternetCases.com. Hello, Evan.
Hi, Denise. Happy Friday. It's good to see you, and it's great to be here.
Happy Friday to you, too. Wonderful to have you back. And we have a special guest for the first part of the show because we wanted to follow up on a story we did 1 or 2 episodes ago, and that is Matt Cooper. He is the founder of AdDroid.com. Hello, Matt.
Hi. Hello. Hi.
Hi. So for those of you who weren't tuned in for our show where we talked about what's going on with Matt and AdDroid, let me bring you up to speed. Matt can tell you a bit more about what his company does, but as I gather from your site, Matt, you're an HTML5-based ad platform.
That's exactly what it is. It's an ad creation platform.
Great. And the name of your site sort of harkens to the word Android, but according to George Lucas, it also harkens to the droids in the Star Wars saga epic of stories and movies, and you were on the wrong end of a cease and desist letter about that, and I'm wondering if you could just bring us up to speed on what's going on there.
You know, I don't know what's going on. I'm in a weird limbo right now. I'm trying to put together my startup, looking to launch 2011 in January. I'm a little bit confused because the lawyer of the rich guy sent me a scary letter, and I don't have revenues yet, so do I incorporate? Do I start pouring more money into the name? Do I keep marketing under this name and really committing to it, and then I'm going to get killed with a lawsuit that a lot of experienced people have told me that ultimately I may win, but just forget it, Matt, it's not even worth it. So I really right now I'm in limbo. I have a really scary letter, and I'm kind of waiting to get sued, I think, or not. I really don't know.
You don't have counsel on board to help you out and analyze the issue?
I have, like 1 or 2 people sort of in the wings who are like, well, let me know if you get sued, and then we'll go for summary judgment or something simple and just see what happens. But I haven't been sued. I have a letter. I have my trademark lawyer who's, the trademark hasn't been stalled in any way yet. It's still just sort of sitting there waiting to be
Right, you have an application in.
Yeah, I do have an application in to just trademark the name, as I'm just sort of trying to lock up the IP of my startup. So I don't know.
Yeah, I'd love for us to be able to sit here and give you specific advice. We really can't do that because we're not your lawyers, but we can talk about this situation in kind of a general way and how one can lock up a trademark on something like Droid, which seems to have a lot of applications beyond just the Star Wars franchise. And Evan, do you have any general thoughts on this sort of issue and someone with a trademark on something like this coming out and sending a C&D early on to a startup like Matt is experiencing?
Well, these are always tough situations, and I would venture to guess it's a tough situation for George Lucas as well, even though we might think that, he and his cadre of lawyers and, his Death Star of lawyers is, just going around picking on people and they have no conscience about it. Trademark law, just by the way it works, puts brand owners, trademark owners in a precarious situation sometime because of this obligation that they have to police their marks, making sure, and what I mean by that is, going out there, making sure that there aren't other participants in the marketplace using the same or similar, confusingly similar mark for, the same kind of goods or services. So I would think that based on experience that I've had, even writing letters for clients in the position of a potential plaintiff, they worry probably about the perception of being bullies and going around looking, for other potentially infringing uses of the mark here. But there's that risk that if the brand owner, the trademark owner, doesn't go out and stop others from, keep the space around their brand clear, they run the risk of weakening the distinctiveness of the mark, and in a worst case scenario, having it deemed abandoned, having no trademark rights at all. Then, of course, it's equally tough in the position, if not more difficult, in the final analysis, to be in the position of the recipient of one of these cease and desist letters. And that's where I find myself as legal counsel very often dealing with startups who have gotten these kinds of letters. And the worst thing about it is that it just, as you've said very well, Matt, kind of puts you in limbo, or at least a weird place of not knowing how to progress further. Not really knowing what's coming around the corner, as if starting a business isn't difficult enough the way it is. There's this added uncertainty with it there. And again, we're not in a position to make suggestions to a particular situation here, but we can speak to what people do sometimes when they're in this kind of situation. There's a right to to ask a court for a declaratory judgment. And what that is essentially is if a person or a new company, or any company, not just a new company, if a person or a company has gotten threatening letters and the circumstances are such that there really is a potential case or controversy going on here, you can go to court preemptively. And we'll probably talk a little bit about this later in the show with the IVI situation, going to court preemptively and asking the judge to say, Judge, I've gotten these threats from so-and-so saying that I am, doing, and then fill in the blank, infringing their trademark, have breached a contract, am, doing whatever. Judge, tell them I haven't done anything wrong and to leave me alone, essentially is what a declaratory judgment action, is. But that's federal litigation. It's expensive. Most startups aren't in the position, nor do they have the desire to do that. But that certainly is something that happens not too infrequently when cease and desist letters reach a recipient and the recipient feels strong about their rights and the defenses they would have. They go to court first and kind of preemptively head this dispute off at the pass by getting bringing the question to the court earlier rather than later, rather than just sitting around waiting to get sued. So that's how I see the landscape that we've entered into here.
I'm looking at the demand letter you received, which folks can check out over at Jason Kincaid's post at TechCrunch. These are not the ad droids you are looking for. He's embedded a copy of the letter there, and it looks like Lucas has various droid marks, including droid itself, hit droids, battle droid, destroyer droid, iDroids Mania, and various other things listed in the letter. So, Eric, we've got Morrison and Forster teeing up against poor Matt here. What do you think about the ability under trademark law to lock up something as generic as droid? Do you think that this is a pretty reasonable way to interpret one's mark?
It's not atypical for trademark owners to have a very expansive view about the scope of their trademark rights. I think on our last TWiL call, didn't we discuss the Facebook action against TeachBook? Or am I confusing conversation?
Yes, we did.
But, a prime example where, Facebook is looking for people who might use the word book and potentially asserting that they're transgressing Facebook's rights. Obviously, the Star Wars properties generally are cherished cultural institutions, and so the caretakers of those institutions are not unsurprisingly looking to as I think Evan said, give them as much space around their marks as they can. Let me, however, express a contrary view perhaps to Evan. The scope of a policing duty, I think, is often overstated on the part of trademark lawyers. It's not entirely clear to me that an ad droid for an advertising online advertising network has anything to do with the space around the trademarks that Lucasfilm is hoping to preserve. And therefore, it just seems like any risk about having circumscribed rights for failing to go after Android just seems a little bit unlikely to me. So I'm always skeptical when trademark owners trot out the idea we have to police our trademarks in order to preserve their full vitality. A lot of times that's frankly overstated, and it leads to a lot of wasted motion, and in some cases really silly complaints. I'm not going to say that this one is clearly silly, but it's certainly at the border of the kinds of things that trademark law should be concerned about.
Right. Clearly, I mean, I wouldn't say it about this situation, but, trademark lawyers sometimes may need to, for whatever reason, reaffirm or reassert their relevance to a situation. So clearly that's in the interest of a lawyer representing a prospective plaintiff in one of these actions to have that expansive view, no doubt.
We've talked about the moron in a hurry standard before. In fact, we named one of the shows that recently. Eric, can you explain to us how that comes into play in a situation like this?
Yeah, we can. And at some point, I would like to address the question that was most on the table, which is what should Matt do? I'm not going to render legal advice, but I would actually like to get to that one
Sure.
at some point.
I'm sure Matt would be very grateful.
Because I have some strong thoughts about this. I have some firsthand experience that might be useful. But going back to the moron in a hurry, so one of the many barriers to Lucasfilm's successful assertion of its trademark rights is that consumers have to, there has to be a likelihood of consumer confusion about the source and origin of goods and services in the marketplace. And given that there are so many different possible angles to take here when we think about what the word droid means, or what we think about the word android means, or what the word adroid might mean as contraposed to those other types of terms. At the moment, there's no reason for me to believe that a consumer is likely to be confused about the usage here as it relates to either Lucasfilm or, as TechCrunch pointed out in its post, to Google's Android. All of these companies can sit next to each other, and consumers have the capacity to figure it out. So when we, one of the challenges that we have in assessing the situation is figuring out exactly what consumers would think. And if we assume that the consumers are, as the phrase implies, really dumb and don't pay attention very much, trademark owners get a much bigger footprint on the overall namespace. But that's not the right test. The right test is a little bit more rigorous and assumes that consumers are a little bit smarter and a little bit more careful than that.
All right, so let's get to where Matt finds himself now in the unenviable situation of being teed up against Lucasfilms and Morrison and Foerster. What do you think you should do, Eric?
So my experience has been that entrepreneurs fall in love with their names. The branding process is an intensely emotional one. And so not atypically, founders and entrepreneurs become instantly wedded to a name. and sometimes to the detriment of what might be the best business call. And as a company grows, it gets more links from other third-party sites to its domain name, which actually over time makes it more expensive to switch brands. You lose some of the search engine visibility if you switch a brand. Unlike now, where Android is a startup, the switching costs are much lower to make that cut. So in some sense, if a name change is in a company's future, it always makes sense to do it at the earliest possible time when there's less investments made in the brand and there's less cost in terms of search engine profile from all the established links. So from my perspective, unless there's an immutable, compelling reason to like the name Android, not because the legal battle can be won, but because it just would be so much easier to build up a name for a company that hasn't launched and hasn't had already all those links established throughout the web.
Yeah, the other thing that occurs to me as you talk through that, Eric, is we mentioned Android as a generic term. Do androids dream of electric sheep? But also, of course, there's the Google out there and its ad platform and its Android platform. And they haven't made themselves a nuisance for you yet, Matt, but it's certainly conceivable.
Well, Android is certainly before we trademarked it, we looked at Android, and it's only trademarked as a phone operating system. And period. That's really it. There's absolutely nothing mentioning advertising, digital advertising at all.
Right.
Also, regarding the name, I mean, a lot of people have just told me, well, just change the name, son. You figure it out. You can do it. It's not a big deal. I thousands of dollars. I didn't buy the domain on GoDaddy. I had to purchase it from somebody else. I thousands and thousands of dollars. It's not a trivial amount of money that I've spent, branding this already. And so it's not. I can't just suddenly pivot because I got a letter, and just think of a new wacky name and whip up a logo. It's actually a little more convoluted than that. The whole wireframe for the site theme, everything is really done. It took really months to sort of get to that point. So it's because I just have a letter, it's not really an option for me to just change. That's simply. So it's going to have to be a little more. I will actually, just for the mathematical part of the money, have to spend a little bit more money to sort of defend the little tiny bit of what I have right now with Android. Otherwise, it's just it's just a little unfair.
And just I'm sorry if I can jump in on that. Yes, all of that is true. My only observation is that when I've dealt with entrepreneurs in a similar situation, looking back a year or two later, invariably they've been pleased about switching over to a new name. So as painful as it may be, I just want to put out there that if you are going to ever make a change, it's so much easier to do it earlier rather than later. You get much better ROI on the investments if you do it. And as I said, entrepreneurs, when I talk to them later, say, "Oh, I did not want to change my name. It was so painful. It was so expensive, et cetera, et cetera." And then a year or two later, they say, "You know what? Actually, that was a really good call. I'm really happy I did it." So I'm not going to say that applies to you because obviously you have your unique situation. But when I've seen this before, invariably the name changes ended up being a very good call. But in this case, I would simply ask the question about if you're a small startup with limited capital, you've already invested some in a name to get as far as you have. But if in fact you do get into legal battle, will the dollars invested in that legal battle will you get a good ROI on those? From my perspective, I think the answer is pretty clear.
All right, Matt. Well, we really appreciate your coming on and keeping us up to date on this. It's an interesting story, and we wish you the best. And I'll check in with you in a bit and see where you're headed, okay?
All right. Thanks a lot. Thanks for your time.
Yeah, in the meantime, folks can find Matt at adroid.com, and it's adroid_com on Twitter, yes?
That's right.
All right. So check him out there.
Okay. Thanks, Denise.
Thank you.
Bye-bye.
Bye-bye.
Later, Matt.
All right. Well, from one startup to another, let's talk about IVTV, guys. I've been finding this quite interesting all week long as the news has unfolded about it. IVTV is another startup. It is taking, well, the technology of it is a little bit difficult to understand, as is the way in which they're trying to work themselves in under the copyright law. But I am best understanding it myself in they are trying both legally and technologically to put themselves in the position of a cable or satellite television provider. In other words, they are taking the broadcast signals, rebroadcasting them the way that cable and satellite do, and except without explicit agreements with any of the broadcasters. And there is a provision under the Copyright Act for that to take place and for a statutory fee to be paid. It's a bit unconventional, but I think satellite TV was pretty unconventional when it first came out, and we had a whole bevy of back and forth there about what they could carry and whether they could carry the local channels, and there actually had to be separate legislation enacted for that to happen. So here we have Ivy trying to insert themselves into the web slot. They don't want to use pipes or boxes. They don't want to use satellites. They want to use the interwebs that are already there, and they want to charge people, it's about $5 a month, I think, to get their broadcast television via the internet this way. They went ahead, as Evan alluded to earlier, and filed a lawsuit in Washington State wanting to get relief from a court saying, hey, what we're doing here is just fine. Interpret the law for us and tell all these broadcasters that that's the case. Meanwhile, a second lawsuit has been filed in New York by the broadcasters, a whole bevy of them, saying, no, Ivy, this is infringement and everything else. So that's where we stand now. And I have been trying to wrap my head around both their technology and the law as it might apply to that technology. And I'm still in the process of that, frankly. But I thought it would be fun to talk about on the show because it's new and interesting. And, the people have cast it as the next Napster. Eric, have you looked at this? And what are your initial thoughts?
Dealing with the statutory licenses for retransmission of broadcasting is 1 degree outside of my sweet spot. So the technical questions on the table escape me a little bit. This reminded me a little bit, though, of the Cablevision lawsuit, the Cartoon Networks versus CSC Holdings case, where a cable company was splitting its stream, continuing to deliver cable broadcasting down to its broadcasters, but then creating a database of content that was effectively a DVR as a service. And I always try to wrap my head around that lawsuit, trying to figure out why the content broadcasters objected to Cablevision creating this DVR as a service. It was strictly about money. We're just talking about cash, and content broadcasters want it, and somebody else has it, and there's not a whole lot more to say about the lawsuit than trying to figure out what the law says and who gets the cash. I will add that one thing I find very interesting about IVI is that they represent kind of the classic wildcatter entrepreneurship in internet law, that they look for a regulatory gap and try and take advantage of it, and make some investments trying to build upon what they think the statute says. And going back even to Napster thought it was okay. It proved that they weren't. But we see that with some frequency on the internet, and it's an interesting investment for the investors to make, to say whether or not they want to make a gamble on basically what is ultimately a legal question. And we're never going to know if that investment is going to pay off in the marketplace until we get through the legal battles.
That's exactly what these folks are doing. They've gone ahead and decided that they are I'm not sure, I'm looking for the precise term, but it's a cable network or someone that falls within this secondary transmission rule under the Copyright Act. I think it's a really interesting situation. And you're right, Eric, that they are gambling on their legal analysis here in order for their company to survive. I've been going back and forth with one of their PR people, and I hope to write up a post over at ZDNet with a little bit more detail on this if I get time in the next couple of days. But he's been telling me some interesting stuff. I mean, at first I wasn't sure whether they, were actually how they were accomplishing this, if there was just maybe a cable or satellite box set up somewhere in their offices and they were taking those transmissions and reusing them in the way that a TiVo box would, say. That's not what's going on, apparently. In fact, they say it's nothing like that. We have servers set up in each market that capture broadcast signals, and then our proprietary technology delivers it via the very lightweight app. They're rolling out new cities every 45 days, with Chicago and LA up next. Right now they have New York and I believe Seattle. And they are giving users all the popular national programming. They say every hit show from all major networks. Adding each additional market just adds the local news and channels. And of course, that's something that satellite had to contend with too, is how it would be authorized to carry the local transmissions. And that's where Congress had to ultimately step in. It's good for competition, that's for sure, to have another outlet, perhaps far cheaper, if you're talking something like $5 a month, than conventional cable or satellite. But then I'm not sure, what it means by all popular national programming. It's definitely a bold move, and I'm interested to see how it all pans out. Evan, what is your initial take?
Well, for as much as we malign copyright for being out of date and not able to adequately handle innovation and new disruptive technologies like this, maybe we can look at this situation positively and see this as the best possible way that innovation and disruption can be taking place here. And I'm basing that on a few observations like the following. One, no doubt is it IVTV? Can we agree on a pronunciation? It's a weird word.
That's what I'm calling it, IVTV.
Yeah, IVTV. IVTV certainly had the notion. It knew that it was going to be involved in a legal tangle because it launched on September 13th, and then there was a lawsuit on file, a declaratory judgment action on file a week later, and that's not really enough time to launch, figure out you might have a problem, retain counsel, draft a complaint, and file it, and all that stuff. They knew going into there that they were going to get into trouble, and I bet you that they also budgeted for this too. Part of the capital that they have put together for this, no doubt, includes some kind of war chest to fund litigation. And so there's no surprise that there was going to be a tangle like this. And since they knew this going in, and since they were put in a position by virtue of this potential obstacle of copyright law, they looked at it from all of these scenarios and were prepared to, in connection with developing the technology, also prepare to deal with these legal issues. Now, if there weren't a real incentive to develop the technology and see its potential marketability and its potential use, they of course wouldn't have invested in the technology, and they also would not have in tandem invested the money used to fund this litigation. So what we're seeing here is an assembly of forces and interests and capital put together in a way to really manage this issue through the potential copyright obstacles, or around those potential copyright obstacles, in a managed and probably focused and somewhat well thought out way. So I don't think anybody here, even the most ostrich in the sand type of incumbents within big media. And what I'm trying to say is, even those within big media who would be so resistant to this kind of change, I don't think even the most resistant among them would think that a new mode of transmission, a new way of getting content and stuff out there is inherently bad. This has the real potential to fill a market space and to provide additional means for advertisement. That's one way that the broadcasters can really benefit by this, is having more people see the content and more people see the advertisements if they're getting it in ways that they want to get it here. So I think everybody probably knows, at least in a little portion of their brain, that if this technology makes it through, or maybe we shouldn't even say if, but when this technology makes it through and finds its way into the marketplace, either by, victory on IVTV's part in the judicial system, or through some kind of omnibus licensing arrangement of the technology between the developers of this technology and big media, once it's out there, it's going to benefit everyone. And so it's good to see it happening this way, rather than well, I guess there's really no other way we could expect it to be happening. Maybe maybe it would just be a half-hearted effort that would just get quickly squashed. I think what I'm trying to say is it's good that there's this concerted effort to manage it through the legal issues from the get-go.
Mm-hmm. And just a couple of observations before we round out this discussion. One, I mean, it's completely understandable why the broadcasters have come down like a ton of bricks on these folks, and that word is mobile. Ivy hasn't gone there yet, but you can imagine that being able to turn a phone or an iPad or other mobile device into a television on the fly is something that the broadcasters have been hoping for themselves and hoping to monetize themselves in various ways. And to see a third-party startup come in and sort of steal that out from under them, it has got to be rubbing them the wrong way. And as does, I think, leaving aside the legalities of it, just the fact that they are used to doing business with distributors, cable companies and satellite companies, where they, are negotiating these agreements and carriage arrangements upfront and in advance. And I don't think, no matter what the copyright law actually says, that's just not my perception of how those businesses actually run. That there's not just a quickie statutory fee paid. There's a lot more on the table, I think, and a lot more nuance to those arrangements. But again, like Eric, I'm out of my comfort zone on this. I'm not a telecommunications lawyer. None of us on this show today are, but do stay tuned for this discussion to continue at a later date. On October 15th, I'm going to have John Bergmeyer from Public Knowledge join us to flesh this out in greater detail. And he is someone who understands these issues quite well. And Public Knowledge has looked at this stuff from Ivy and is planning to write about it soon, and thinks that they are right where they should be, and that they're forging ahead and actually have solid legal ground to go forward on. So we'll stay tuned on that, and look forward to having John on the show in a couple of weeks to further enlighten us. Google has been busy in the last week or so itself with Google Instant. And, that came out and didn't really surprise me or really change my life too much, since I mostly use the Google search box in Firefox for my searches, and it has behaved like Google Instant behaves for forever, as far as I can remember. But, now the rest of the world is experiencing that on the Google site itself. And it really didn't occur to me that there was a legal issue to be had there until I saw this story about, and this was from Christopher Dawson, who was on the show last week with us, about Google blacklisting certain queries. And what, let's see, the story originally was from theinquirer.net, and things like, and they actually, let me read the quote that Chris quoted, because it's quite good.
Oh, no. Here we go.
A lot of the words that are being blacklisted are urban slang. So, for example, camel podiatrists will find searching for information about their words a less than instant process, as will anyone looking for work in a factory that packs fudge. So you can see that Google is trying to edit the results that show up in Google Instant. And what occurs to me is that some trademark holders are bound to be up in arms about that, in the way that trademark holders have traditionally been up in arms about Google for the way that they show up in search results. And Eric, I wonder if you have any thoughts on that.
I'm still trying to get my head around Google Instant. I haven't decided if it's just a minor UI tweak or if it completely changes the way that we think about search. Back in the day, it was very easy. You saw a static page, you put in a search query, you waited a second, you got static results, and then you evaluated them. If you didn't like it, you did another search, or if you liked them, you investigated them. And Google Instant changes that because there's the notion of the static nature of either the search or the search results is completely gone. But it's not clear to me that that actually changes anything from a legal standpoint. So, for example, if Google were blacklisting particular trademark terms as a way of hindering competition, that would be an issue. That could be a real problem. There are plenty of people who are unhappy with Google's alleged efforts to thwart competition generally. But I don't think that's what you were asking. I don't think we have a lot of evidence to support that. If it's simply that because Google puts in, when Google sees a trademark, it starts prompting a bunch of searches. In fact, Google's been doing that for a while with third-party trademarks, and surprisingly, they haven't been getting a lot of complaints. So, for example, Google will highlight certain brands and say, I see you're looking for a digital camera. Here are some particular brands that you might find relevant. I haven't heard trademark owners complain about that too much. Another thing that that Google would do, obviously, is make it suggestions. It would say, I see you're searching for this brand. Have you thought about a bunch of other brands? Again, things that trademark owners have been pretty tolerant of. So my initial instinct is that Google Instant doesn't change any of those discussions, that we're not actually talking about a change in Google's underlying legal profile. We're talking about just a UI tweak.
Mm-hmm. Evan, any thoughts on Instant?
Well, everything Eric said. It really just seems like search has been made, more Ajaxy. That's all I really see. And Ajaxy, just as a kind of a general adjective there, I don't know how the technology really works to deliver instant search, whether it's based on the Ajax technologies. But, when you walk around as a hammer, everything looks like a nail. So since we're all assembled here on this phone, we can probably bring a Section 230 issue into this.
Do it. How do you get there?
Right. Well, the article that we're looking at here, talks about, really focuses, in the quote that you read from it that Chris wrote, focuses on Google blocking out these terms that might be offensive or lewd or lascivious or whatever. You were talking about, I won't even repeat them. I'll get too Beavis on us here. But, one of the things that Section 230 does in Section C, that portion of the law that we love so much, is it makes providers not liable for any actions. And I'm just reading directly from the statute here, any action voluntarily taken in good faith to restrict access to or the availability of material that the provider considers, among other things, obscene, lewd, or lascivious. So, if we're going to, go after Google for somehow being all overly restrictive, I can't even articulate a real theory as to, a real good theory as to how Google would be breaching some kind of public trust or doing something by blocking this content. Even if we were able to articulate even if we were able to articulate a tort theory against them for that, assuming that it's not some criminal allegation or intellectual property infringement, Google would appear to fall under this protection of Section 230 for taking these steps in good faith to restrict, the kids in the classroom from reading too much about camel podiatrists. So, go for it.
All righty. Well, I think we have done that one quite into the desert dust. So let's go to Suddenlink, which Torrent Freak is reporting. Suddenlink is an ISP somewhere here in the United States. And Torrent Freak is reporting that they have voluntarily implemented a 3 strikes policy for their subscribers. So this is something that we've talked about before in connection with ACTA. One of the controversial aspects that bit of international negotiation is that it has been cast as something that will require ISPs to have a 3 strikes policy for their subscribers. That is 3 DMCA notices related to their subscribers' activities, and they're out of internet service. So Suddenlink is doing this voluntarily. There's a exchange back and forth with someone from Torrent Freak and Suddenlink about whether that is a legal requirement or whether Suddenlink is casting it as a legal requirement. It sounds like the person on the phone there didn't quite understand whether it was or not. It sounds like that what they're trying to communicate is this is our policy, this is what we're doing, and if you don't like it, you can find a different ISP. And so that's just the course they have decided to take. And Eric, I'm wondering if you've heard of other ISPs deciding to comply with this desired approach of the rights holders, or if this is the first, and what you think about this.
So we have to pull apart the DMCA's requirements or even understand what's going on. To be eligible for the online safe harbor in 512, the service provider, under some provisions, is required to terminate repeat infringers and to have a repeat infringer termination policy that's articulated. And so I think that a number of service providers have a form of 3 strikes rule where they will, if someone transgresses the service provider standards 3 times, that they'll terminate service to that user as a way of providing evidence of complying with that requirement of the online safe harbor. So at that level, actually, I think it may be fairly common. What's unusual here is that this particular service provider is, I believe, taking that position with respect to internet access, which is the kind of 3 strikes issues we see in France, for example, that the person would be cut off of their internet access for being alleged to be an infringer. I believe that the online safe harbor does not require internet access providers to take that action. And certainly, were they to do so, they would want to be very precise about what constitutes a strike, whether it's simply an allegation of bad behavior or actual confirmation of bad behavior. I think there's a significant difference. There's no barriers to someone saying that a subscriber engaged in infringement. There's a lot of barriers to proving that the person actually did so.
Right.
So I can't think of another internet access provider that has adopted a 3 strikes policy based on allegations of copyright infringement leading to a termination of internet access here in the U.S. So in that sense, I think that we've got something new going on here. But because there are all these other reasons why people have some form of maximum strikes policy, it's a little bit hard to pull that all apart.
Yes, you hit the nail on the head for my concerns. You know, obviously ISPs can take whatever policy they choose to adopt as part of their business and as part of their legal obligations under the copyright law. But yes, I was very concerned about what sort of challenge process or appeal process there might be in place here. And I haven't contacted them to find out what that is. And it's not clear from the Torrent Freak story, but it does give me pause on that front. Evan, any thoughts?
Well, you know, what we might have here is nothing more than just a story based on the misinformed actions of a single customer service representative. I don't have the article in front of me, but I don't remember Suddenlink coming up, you know, making some official policy statement that this is what it was. It was just, you know, the transcript of a chat with a customer service rep here. And I mean, if that is the official policy of the ISP, then I think we all agree that that is an incorrect reading of the DMCA to say that it's required under the DMCA. You know, thou shalt terminate the user's internet service for 6 months. You know, that is not in the DMCA at all. And it's in section 512I1A where we get this, this notion of terminating repeat infringers. And if you look at the language of that, there's enough wiggle room for providers here to make it abundantly clear that this is not a requirement that, thou shall terminate repeat infringers, but there certainly is an incentive for providers to terminate repeat infringers because they clearly fall within I'm not going to say clearly, but they will fall within the protections of the safe harbor if they do that. I represent intermediaries who have to respond to DMCA requests on a daily basis, and I can tell you that is a huge thorn in their side. So even when it's good paying customers, providers themselves aren't going to really lament terminating these pesky folks who are accused of infringing, they're not going to lose a whole lot of sleep, having to do that at least once in a while. But it's kind of interesting to look at where the wiggle room there from Section 512 I1A, how that reads. It says that the safe harbor provisions apply only if the service provider, among other things, has adopted and implemented and informs subscribers, which means puts it in the terms of service, that the ISP has a policy that provides for the termination, and here's the good part, in appropriate circumstances of repeat infringers. So there seems to be a huge latitude there for what the appropriate circumstances might be when a provider is going to terminate a purported repeat infringer. And not among the least of those things that would make it appropriate in the provider's mind is the pesky nature of just having to deal with these gosh darn things, these DMCA takedown notices that are coming to you all the time.
Yep. Well, I want to get to some updates in litigation we have followed over the months of the show, new developments in Pirate Bay, and a preview of what we might see on appeal in Google versus Viacom, and also pick Professor Goldman's brain on some recent issues. But first, I'd like to thank our sponsor, Squarespace.com. For anyone out there who has a blog or a website, you've got to go check out Squarespace.com and consider whether your current setup is really meeting all of your needs, because Squarespace is amazing. They are now managing my online presence at bagandbaggage.com, which I've had since 2001 when Blogger first came online. So I was able to easily, really, without any struggle at all, import all of my going back to 2001 content into the Squarespace platform. And it really is a nice place to be. It's a fast and easy way to publish really an excellent website or blog. You can make this look however you want. And I encourage people to go to squarespace.com/examples and take a look through their 7-page gallery of all the different kinds of sites you can create with Squarespace. It can be a blog, it can be a full-blown business site, it can be something whimsical and personal. Whatever you really want it to be, it will do it for you. And they manage both the creation and the design with a series of excellent templates, and also the hosting, which is, ironclad. There's really no way to bring down a Squarespace site that I've heard of unless they have some kind of catastrophe, and I've been with them for over a year now, and nothing like that has ever happened, which is refreshing in the world of site hosting. So you've got to check it out for its easy-to-use UI. It's optimized for both beginners and CSS experts. There are hundreds of design templates to choose from, and you can customize them all really easily in a very WYSIWYG way. It's an all-inclusive service. So for your monthly fee, which varies on what kind of plan you'd like, but it's all very reasonable. You get several modules to build your website. As I said, you can have a blog, you can have a forum, you can have Flickr photos. They have widgets that interact with all the social networks. There is wonderful tracking and statistics built right in. There's search engine optimization built right in. There's permission access handling, cloud architecture for speed and stability, and an innovative drag and drop Ajax interface, an iPhone app that makes it really easy to update your anything you're doing there on the go. So you can build it, host it, and update it anytime using squarespace.com. And you can also get 10% off the lifetime of your new account by going to squarespace.com/TWiL and using this show's offer code, that's TWiL, and sign right up. You can try it for 2 weeks without any sort of commitment. Go on over to squarespace.com/TWiL. So let's get into what's new with the Pirate Bay. Apparently, the folks there are in the process now of appealing the large judgments against them. I guess there's no surprise there, but just wanted to give folks the update that moves along apace. Eric, any thoughts about these guys and what they might do next?
I couldn't even speculate about that. It's a pretty crazy situation.
Right. They've been formally charged and all pled not guilty, but they are definitely in trouble with jail time and $1 million each or so in fines. Evan, any thoughts about Pirate Bay as it moves forward?
Well, I waver when it comes to what to think about these guys, and to the extent that they also are just a proxy for the larger question as to what it means to, or, as to the larger question of how restrictive or how strong one should enforce his or her copyright rights. And lately, I've just been in so much more of a mood to see these guys as not well motivated. I think that they are just too far over onto the well, good grief, they call themselves the Pirate Bay. They are pirates, and I really think that, I mean, as with any issue, and I've said this time and time again on the show in a number of different contexts, anytime you're going to be so radical in your position, you're not doing anything to bring over everybody that's either to the further left of you or to the further right of you. Those people out there in the middle, you're not doing your cause a service. Just because you're going way out there, you're not extending, the center of gravity more to your direction. You're doing, you're turning people away, and you're repelling them, and you're, if anything, putting them to the other side of things. And this is just a fundamental observation about sociology and the political nature of humankind that I'm making here. And these guys now, I just see as doing more harm than good to the noble questions of fair use and innovation and ways of seeing equitable compensation for the use by the creators and in the subsequent reuse of copyrighted works, in remix culture and all of that stuff. So right now, I'm just wishing these guys would. Maybe I just wish people wouldn't pay so much attention to them right now.
Well, we'll see what happens with their appeals and if they get any relief from the rather severe penalties they're facing right now. Viacom is somebody else who got their hat handed to them in a court of law. And though they have not yet filed their appeal, which will happen in federal court, there is a gentleman named Tom Snyder who, I'm sorry, it's Sydnor, Sydnor, who publishes over at the Progress and Freedom Foundation and seems to be, one of the loudest advocates out there for how the ruling in favor of Google was just dead wrong and needs to be thrown out. And he's given something of a preview of coming attractions for how Viacom will be challenging the trial court's ruling, discussing that the DMCA's civil safe harbors protect even intentional, massive, and potentially criminal wrongdoing. That's how he is saying the trial court interpreted the statute. I don't know that I agree with that. And it says that he believes the court confused the usual meaning and reversed the usual meaning of familiar terms of art adopted by the DMCA. Eric, did you take a look at this, and is any of this causing you to fear for the stability of the summary judgment that was granted in Google's favor?
I didn't trace through all the arguments, and I hate to say it so bluntly, but I didn't consider it to be worth investing in. What I find so frustrating about the Viacom versus YouTube lawsuit is that the rhetoric is so extreme, so outrageous, and it masks the fact that Viacom is happy with YouTube and loves YouTube in the sense of using it extensively for its marketing purposes. And so all this about, the death of copyright and, abuses of the statute and all that, I don't even know what they're talking about. I can't understand what they're talking about. We're dealing with a problem from days of yore that, in my opinion, if there ever was a problem, got thoroughly fixed. And so I just don't even understand why the rhetoric gets so out of control in this case. It's really not about the balance of copyright. It's about Viacom saying you didn't have a right to found that way, and we would like a lot of money from you, and YouTube saying, "What's the problem, Viacom? You seem to be happy today."
I think one of the motifs that's developing from this episode is that people just need to get over themselves. That's what I'm seeing.
Well, the wisdom beyond the courtroom as well.
Well, certainly when it comes to IP owners, we could go on and on with examples where IP owners are very impressed with their intellectual property in ways that not everyone else might be as impressed.
So, Eric, I didn't want to have you on the show without talking about Dr. Glenn Reet and the hazards of critiquing one's dentist on Yelp. Do you want to? Want to bring us up to speed?
I don't. I'm not going to talk about my dentist. They have the ultimate capacity to dispense pain. The next time I come in for a visit. So, dentists are off limits when it comes to online consumer reviews in my world. But in all other respects, there's some very serious issues about the battle that's taking place between businesses unhappy with negative consumer reviews and the desires of consumers to get more information about goods and services in the marketplace. What's happened over the last decade or so is we've seen the emergence of a whole variety of new platforms for the aggregation and organization of consumer reviews. Businesses unhappy with those reviews have targeted these aggregators and tried to get control over their, quote, reputation. So Yelp is an example of an aggregator. Prior to Yelp, I think it's fair to say that there was no really good place to get consumer reviews about local businesses, whether it's auto mechanics or professional service providers like dentists or doctors. Prior to Yelp, there just wasn't a really liquid ecosystem for thick and first-hand reviews of these local businesses. Not surprisingly, though, local businesses tend to be a little bit smaller. I don't want to call them all mom and pop, but the idea is that a lot of times there's a very close linkage between the business's identity and the founder / entrepreneur / principal's identity. And as a result, a lot of local businesses have pretty thin skins. They really are unhappy with negative reviews. They take it personally. So in a recent case, we had a doctor in New York who complained about Yelp reviews. He couldn't fully understand how Yelp had organized the reviews and why some reviews were showing up and others were suppressed. That is a common complaint against Yelp. It's one of my personal points of confusion about their business generally as well. But he sued Yelp then for not removing some of the reviews that he thought didn't belong there. And the court said, sorry, no dice. Yelp is not liable for those consumer reviews. It's a very logical outcome based on 47 U.S.C. 230. I think it's a logical outcome from the perspective of balancing between business owner sensitivities and consumers' need for firsthand opinions. So from my perspective, it seemed very much straight down the middle. But certainly there are a lot of local business owners who would wish that they had better leverage over Yelp or others.
Yeah, it sort of reminds me of people complaining about where they show up in Google standings. It's a question of reputation. But here, as you say, the reputation isn't manipulated by an algorithm, but by individuals, and they can be a bit more mercurial and harder to control and predict. Let's get on to our resource of the week. First, a bit of news related to it. And that is that a number of groups, including EFF and folks that are frequently aligned with EFF, have filed a letter with the Judiciary Committee concerning the Combating Online Infringement and Counterfeits Act that we discussed last week on the show. This is the proposed legislation that would give the Justice Department a kill switch for infringement, basically, against sites that they thought were dedicated to infringement. So basically, the AFF and others have asked for more time and hearings on this before there is a vote. We're not sure how successful that will be. But,
I hate to interject. Did you see that it is delayed for now? That just
is it delayed for now? Good. Yeah. Breaking news. Do tell us what has happened.
Well, I think it's mostly procedural. Politico first talked about it, and there's some stuff over at EFF, and it's saying that it was postponed as staffers anticipated the chamber would finish legislative work and adjourn for recess before the hearing could commence. So I'm not quite clear on exactly why, other than just it simply being procedural things and not having enough time, recognizing that they don't have enough time to consider the potential pitfalls on it here. I'm trying to say it as neutrally as I can. I mean, I'm very much against COICA and all that it stood for, so I'm trying not to say, they saw the obvious, the obvious censorship blacklist problems here, so I'm trying to not be too hyperbolic about it. But I put up a tweet about this yesterday, and the guy over at CopySense, I forget his real name. I know I follow him on Twitter, COPYCENSE. He retweeted it, but also gave a warning, all of this, within 140 characters, to be mindful of, some of the omnibus trickery that can go on toward the end of a legislative session here. So it appears that it's dead, at least for now, but we shouldn't, sleep with both eyes shut yet when it comes to COICA.
Yes, and along those lines, our resource of the week is EFF's Clearinghouse of Information on COICA. It has a long URL, so pull it out of our delicious show notes. It is there, but it's called the COICA Internet Censorship and Copyright Bill over there on EFF, and they have resources, articles, deep link posts aggregated, and various documents and files, including the letter that they and others filed asking for the delay. So we can keep up with what's going on with the legislation right over there. And I have two tips of the week for us this week. One is sort of tongue-in-cheek and sort of not, and one is not tongue-in-cheek at all, and it flows from, Eric, your most recent blog post concerning the discoverability of items that people believe to have been deleted from Facebook. So our tip would be, if you have deleted something from Facebook, don't think that it can't come back to haunt you. Can you tell us what happened there?
Litigators now know that Facebook, MySpace, other social networking sites have just a treasure trove of information that could be helpful in litigation. And so over and over again, I'm seeing cases where the litigators have been able to grab information off of the social networking site and use it in court. There is some information that might not be easily available to those litigators, things that are private and not available for public consumption, or things that might have been deleted. And so we just recently got a case where the judge ordered Facebook and MySpace, effectively ordered the litigant to go tell Facebook and MySpace to do this for them, but it ordered the discovery of information that was both private in the sense that it was not shared with the public, but it was only shared with a smaller circle of friends, and also ordered that Facebook and MySpace would turn over deleted materials that presumably the person who posted them had thought were no longer appropriate to for anybody to see, and yet they were being resurrected from the dead.
Right. So beware out there, folks. Even stuff that has been supposedly permanently deleted from your account can be accessed and can come back to haunt you. Evan, were you going to interject?
Well, I think there's one important point to make about this this case here, and it was from where was it from? I know, Eric, you and Venkat covered it very well. It's from New York, a state court in New York at the trial court level here. And one thing that's important here is that we should be reluctant to just say that because of this case, all social media information that you compile or create is discoverable in litigation here. This was a personal injury case, and the plaintiff, who is the one who has to have Facebook turn over all her stuff to the defendant here, she introduced this issue into the litigation of, her quality of life, her enjoyment of life. She had allegedly suffered these injuries that make it so bad that she can no longer enjoy living, and she's bedridden most of the time and never goes outside to enjoy the sunshine. And purportedly, there were pictures on her Facebook account that showed her in Florida enjoying the sunshine, smiling, happy, apparently experiencing a certain quality of life. So it really, we've still got to maintain a case-by-case focus on this stuff, as with any discovery issue in any litigation, as to its relevancy, not only its relevancy, but its ability to lead to the discovery of relevant evidence here. It's too much to say that this case means that everything you ever do on a social networking or through social media is going to come to light in litigation. It doesn't mean that, but it definitely should be a cautionary tale along those lines.
Hey, Denise.
Yes.
Completely agree with Evan. And two observations. If there was a photo that the plaintiff in this case had uploaded to her Facebook account, and she also had it on her hard drive, it would be discoverable, I believe, in a sense, both places.
Sure.
So, the fact that it was on Facebook doesn't really, I think, change our analysis in a meaningful way. I also was going back and forth with my contacts at Facebook to try and figure out how long they would retain the deleted material, and I didn't get a fully conclusive answer to my inquiry, but it appears like Facebook doesn't keep certain items of information that have been deleted very long. So, for example, if it was a photo and the user had deleted it, as far as I could tell, based on my conversation with them, it would be gone within 90 days. In fact, based on what they explained to me, it would probably gone substantially quicker than that, maybe in a matter of a week or two. So the point is that the fact that in this bigger case, the deleted items were discoverable may not be that big of a problem because Facebook may not have very much that's available. In contrast, other sites might have lots of stuff that they do keep, even though it's, quote, deleted, that they might be keeping for months, years, forever. So in this bigger case, it's not a clear problem to get the deleted items, but we could imagine where in another circumstance that would be a huge surprise.
Yes, exactly. And I think that, as far as people's just common perceptions of what happens when they hit the delete button, they would hope and expect that it would be deleted then and for good. And that's why I wanted to call it out as a tip that that's not necessarily the case on Facebook or really anywhere else. So I had one last tip of the week to round us out with. It comes from Mike Mazik's blog, and he got it from Church Hates Tucker, pointing to the rumor making the rounds that some luxury brand companies are experimenting with product anti-placement. That is, they're sending the competitors' products to celebrities who they think will create a negative association with the brand. So the example would be that, perhaps Louis Vuitton might send a Prada purse out to someone like Snooki to associate her with some brand other than their own, to tarnish the competitor's brand. And the reason I cast this as a tip is because, I have not fleshed out the legalities of all this, but it does strike me as a bad idea. And that, under trademark law, there could be some tarnishment claims to be made there. Aside from the fact that this is a hysterical business strategy, do you guys have any legal thoughts?
I'll take. Go ahead, Evan.
For it.
No, you go ahead.
Okay, good. I'll say something trivial and superficial, and then you can get the substance to it.
Actually, I was going to take the trivial, and so we're in trouble here. Go ahead, Evan.
Here we are quibbling over the triviality.
Who gets to be funny?
Right. Well, there probably are funny things that you can say about it, but I see this as a difficult question from a trademark standpoint, and it's all going to this notion of use. I mean, I think we could talk about things like, what it means to use a trademark, what it means to make some kind of endorsement or association with your company and a product, and we could also talk about, the first sale doctrine here. So we could pick from any one of those ways, among others, I'm sure, to analyze this situation here. But the thing that rises to the top in my analysis of this is, I cannot see how this is trademark infringement because, there's nothing dishonest really going on here. These aren't counterfeit products. I don't think anybody is denying, who's sending them to whom. It's like it's all very, very clear and transparent as to what's happening here. It's just some kind of, there's this really amorphous notion that we can bring up kind of by default if we can't think of anything else, which falls under the huge umbrella of unfair competition.
Yes.
I guess there are ways. It does
strike me as sort of a commando tactic.
Yes. And so there's probably a fine line between being a commando and just being really, really clever. Somewhere around there.
From a legal standpoint, I wrote an article called Brand Spillovers, where I talked a little bit about liability for unwanted adjacencies. And I actually took a look at a variety of ways that those adjacencies get created. And I'm with Evan. I think establishing the legal framework to govern this is really not that easy. But what I liked about it is that it shows how trademarks are outside of the trademark owner's hands. They live in consumers' heads. And so if, for whatever reason, Snooki decides to go out and be associated with Bag A, even whether it's because Bag B got her to do that or because she developed on her own, it's outside the trademark owner's hands to cause consumers to overwrite that association. I remember the situation in England when a bunch of the soccer fans who sometimes are pejoratively called hooligans adopted Burberry as their preferred dress. And there's
Those are
nothing
some
Burberry
upscale soccer fans.
Well, okay. The point was that there's nothing Burberry can do to avoid being associated with, the kinds of soccer fans who might go and trample each other or, throw beer on the other team's players or whatever. That's outside their control. They can't stop people from making those associations. It's just the nature of trademarks, the fact that they live in consumers' heads. So it struck me as a little bit of a play on that. It reinforces that trademark owners wish that they could have complete control over their brands, but in fact they don't.
Yeah, and for another day, we can save the discussion of there are a lot of online commerce sites that try to associate the wares that they are selling, which are not a trademark good, but are like it, a knockoff of a Gucci bag or something. And then we'll show a picture of a celebrity holding the legitimate one and try and make that association. And that strikes me as a bit commando as well. But we can save that one for another day. I'm glad we've been able to end on the note of Snooki. And
Yes.
It's a good way to kick off the weekend. And with that, I'll bid a fond farewell to Evan Brown. Thank you so much for joining us.
Well, thanks for having me. This is it's always awesome to have Professor Goldman. I think I said this sometime before. It's never not awesome when he's on the show. So.
That's true. It's never not awesome. I really appreciate you coming on last minute too, Eric. Folks, go find Evan at internetcases.com and at internetcases on Twitter. And our last-minute life-saving, pinch-hitting panelist, Eric Goldman from Santa Clara University Law School. And your technology and marketing law blog can be found at blog.ericgoldman.org. And Eric's Eric Goldman on Twitter. Do go follow him. He's one of the most interesting folks that I follow on Twitter for sure. Thanks, Eric.
Thank you very much. Glad to be here.
Really fun to have you, and hope to do so again soon. All right, folks, have a great weekend. We'll see you next week for the next episode of TWiL. In the meantime, go check out our Facebook page, facebook.com/thisweekinlaw. We post up pre-show questions and love to get your feedback before the show. Thanks very much. Bye-bye.